So let's start with Mr. Coleman. Argument with regard to not necessarily with regard to the counts and whether or not they're true or not. You may proceed.
Judge, I won't belabor the point. You just heard the testimony. The testimony is fresh on your mind. I think I'll start with what I believe is not even a close call, which is the possession of the firearm and the marijuana. I think the evidence is clear on that, and it certainly rises beyond or more than a preponderance of the evidence based on the testimony and the video that supports the testimony, Judge. This defendant violated condition 1 of his conditions of probation by violating the law, not only by possessing marijuana, and not only by possessing a firearm in furtherance of possessing that marijuana, but also just there was also evidence that he may have been also engaged in distribution of that. And I ask that you consider that as an aggravating factor for punishment purposes, Judge. With regard to the aggravated assault, Your Honor, likewise, I think you've seen the videos, you've seen the photos, you've heard the testimony. I think Robin Wright made a very good point that I didn't think of. Even if you are of the opinion or you believe that there was some failure, and I'm not conceding that, but if you believe there's some failure to yield the right of way, I would submit to you that an individual traveling 72 miles an hour, at most 52 hours at minimum, would make it difficult for someone to judge or recognize that that vehicle is coming at them that fast, Judge, in such a short time frame span. So I ask the court to consider that, Judge, in determining whether or not the defendant acted negligently or recklessly with regard to not only the aggravated assault, but also the manslaughter as well, Judge. And with that being said, I want to make sure I cover everything here. I think that's really all I have on that, Judge. Thank you.
Thank you, Mr. Coleman. Mr. Gertz.
Judge, as to the first set of allegations regarding the alleged marijuana, there's no testimony that this was actually cannabis sativa L. There's not been any expert testimony on that front. And no witness was presented to do that. So unlike lots of other drugs, which are readily apparent as being unlawful, marijuana has a variety of different offshoots that are and can be legal in the state of Texas. And additionally, the firearm, to be unlawfully carrying a firearm, there has to be proof of the sort of precipitory, Judge, offense of some unlawful possession of marijuana. Here again, he is in possession of some kind of green leafy substance, and there was no testimony about what that substance ultimately was. And so absent that, additionally though, Judge, I would argue that the state did not prove the lawfulness of this stop in this case. The Detective Busby testified that his opinion was that this front windshield was too dark. He said he had a monitor, and there's actually a specific requirement that you have 25% light variance in these in the transportation code, and that 25% light variance applies if he has a tool. I specifically asked him, "You have a tool to measure that?" And he said, yes, he did, but he didn't present any evidence that that was actually employed here. And in fact, on the side windows, you could see that he immediately had the windows rolled down. He never checked them again, as far as I'm aware from the video. And he never used the tool to check the front windshield. So just at the very outset, he's making a guess or a hunch that this was, an unlawful window tint, but he didn't actually present any evidence of that other than just his own opinion. And so we object to the stop. We object, and we believe the court, even if the stop were reasonable at its inception, he made no effort to confirm the reasonableness by testing the windshield or the side windows. And then secondarily, again, as we pointed out to the court, there was no evidence of what the content of those bags actually was. Thus, there's no evidence to support him unlawfully carrying a handgun or marijuana. So put that sort of in bucket number one. In bucket number two, Judge, the state has alleged here the offense of manslaughter and the offense of aggravated assault. And I'll start with those two because they require proof by the state. Again, I know it's a lower level of proof at this stage, but they require proof by the state that Mr. Fletcher acted recklessly, that he was aware of but consciously disregarded the risk that this specific result would happen. And speeding obviously is unlawful. He was speeding, certainly, and that's a Class C misdemeanor. He was speeding. But the cause of this accident, and the state's own expert has testified before, and the reason I bring up this other case, Judge, is it is monumentally unfair, in my opinion, that the state, in two cases that are almost identical to each other, take contrary positions when it suits them. In other words, Mr. Coleman wasn't involved in that trial. I'm not attacking Mr. Coleman at all, but it's this district attorney's office has taken the position that, oh no, if you fail to yield the right of way, you're always the cause of the accident. And then in here, they're like, well, no, it's okay if you fail to yield the right of way because he was speeding. Well, you can't have it both ways. And it's exceptionally frustrating because what it appears happens is if someone dies, we figure out a way to make the rule fit for that case. And that appears to be what's happening here. The recklessness falls on the person who didn't die. And that's not how the law is supposed to work. A person is required under the law to yield the right of way, regardless. And I didn't go through the whole soliloquy with Mr. Wright that I did in the previous trial, but I tried to get him 100 different ways to agree with me that failing to yield the right of way was not the cause of an accident because the other person was going too fast. And Officer Wisby said the same thing. She has written lots and lots of tickets for failing to yield the right of way. And everybody always says, well, the other person was speeding. They still get a ticket because they're still the cause of the accident. Here, he was speeding. He was cited for going too fast, I believe. But the actual end result for recklessness purposes is he was not the cause of this accident. The vehicle failing to yield the right of way is the cause of the accident. Mr. Fletcher's speed certainly contributed to it. They wouldn't have been in the same spot at the same time. But as a practical matter, in terms of following the law, the Honda failed to yield the right of way. And that was their requirement, being at that stop sign. And so his recklessness is not the cause of this death in this case. And so for those purposes, and I would say the same thing is true for the negligent homicide as well. Again, you know the difference between the two. I don't need to go through the whole litany with you, but here again, we can have a jury trial about all of these issues and let a jury decide that. But for the purposes of this court's decision here today, there's certainly not evidence that he was recklessly causing the death. And that's what it would have to be. His recklessness needs to cause the death. And that's not what happened here. It's the failure to yield the right of way is what caused the death here. And that's unfortunate for the family and for everyone involved. It's a terrible tragedy for everyone involved. And I'm not trying to belittle that, but we have to be realistic. And the state has to, I would argue, take a consistent position about these cases. And they're not doing that here. And for that reason, we object and we ask the court to either find those things not true or hold them in abeyance and let us have a trial on these issues and let a jury decide with his presumption of innocence, let a jury decide these issues, Judge. Thank you.
So obviously I was inclined to hear this case, the motion first, which is somewhat rare. Typically we'll have trials first, and I allow the state to go forward this way. At this point, well, a couple of things. There was no evidence with regard to the testing of the alleged marijuana. I don't know if there was testing, if there would be at some further. there hasn't been, I looked back, just as I said, I took judicial notice of the court's files. So I went back in the motion to revoke case, and there was a motion to revoke that was filed back in 2024, 3, something like that. There was a hearing, it looks like potentially. And at that point, the state, not Mr. Coleman, but the state over in drug court dismissed that motion to revoke based on that motion to revoke had the two allegations, the unlawful carrying and the possession of marijuana.
If I'm sorry to interrupt the court, Judge, but I've got authority case law that says that an officer can prove up or substantiate marijuana based on his or her training experience alone. The smell of marijuana and the odor, and I'm happy to provide that case law to the court.
That would surprise me if that was now I would love to see it, because then I will take a break to read it. But I mean, it's pretty specific now that there are different types and different levels, and some are legal and some are not legal. And as far as I know, there's nothing that can be trained by smell or look as to whether or not that marijuana is legal or illegal.
And if I may add, Judge, the defendant himself said it was.
I understand, but as in any, look, here's the thing. Do I think it was marijuana? Yes, I think it was marijuana. I think Mr. Fletcher was probably dealing marijuana. That's my opinion. I am constrained by the legal definitions of marijuana and what the testing shows on all drugs. He can think he has cocaine and it turns out to be baking soda, and he would not be guilty of possession of cocaine, even if he thought it was. That's my understanding of the drug laws, and I think that's the problem, and probably why back then there was a dismissal of that motion to revoke filed in drug court that specifically stated, let me find it. It was checked off, why it's dismissed. And that was back on October 16th of 2023. And the mark that was checked off was the evidence is insufficient. So I don't know if there wasn't testing done on the marijuana. I think the testing is required, even as a preponderance. I have notes here. He admitted it was weed. The officer believes it was weed. It clearly was probably weed. Probably weed doesn't get me where I need to be. So I'm saying this for everyone because it's very frustrating for me, because I do believe probably that it was marijuana and that it was illegal, and that Mr. Fletcher was selling it, distributing it, and I mean, you don't have scales and you don't have baggies and you don't have all those things and you don't have a firearm. But for purposes of this hearing, I don't believe I can find that count true based on the evidence presented today. So unfortunately, I am going to find counts 4 and 5 not true based on that today. Now, with regard to counts 1, 2, and 3, obviously this is somewhat a I don't know, I don't want to call it a battle of the experts or whatever. I don't see how the speed that Mr. Fletcher was going did not have obviously some cause and causation in this wreck. Also, there was no testimony that said all the testimony that we heard today was that there was in fact a failure to yield, which is extremely unfortunate. And I think what I am inclined to do, and what I was probably already inclined to do before Mr. Gertz mentioned it, is hold off on making a finding in counts 1, 2, or 3. I think all of that probably needs more hashing out, more evidence than what a short hearing would give. Obviously, a jury or even me, if it were a full-on bench trial where it was beyond a reasonable doubt. I'm not inclined to make that decision based on a preponderance of the evidence because of the conflicting evidence and things like that. So what I intend to do is I'm going to hold this motion in abeyance. We do not have a current trial setting, but I will get one very quickly. The case will be tried, a jury will determine whether or not Mr. Fletcher did in fact commit the offense of manslaughter, the lesser offense of criminally negligent homicide, and or the aggravated assault with a deadly weapon. I think that's probably the better and more fair way to do it for everyone. I don't want anybody to feel like they wasted their time today. But based on the evidence that I heard today, which I would not have known had we not had this hearing, kind of wouldn't have known how to go proceed. So I would say we know that now. I'm going to hold the matter in abeyance. I am not going to make a finding on counts 1, 2, or 3. I'm going to hold making any finding. And then we will see what happens with that trial. That's not to say either that after a trial, even if a jury finds Mr. Fletcher not guilty of those offenses, that with further information that I believe I could legally take into consideration at a trial, I could still find these matters true, some, all, or none of them, after that hearing, based on the evidence I've heard today and the additional evidence that I'll hear at trial. So the motion's not gone. There's still that possibility. But I think legally and in all fairness to everyone, that's the proper way to handle this matter. I will get with Ms. Holmes today. Again, we will get a trial date extremely quickly as we possibly can. I know everyone is suffering and needs some closure to this. I apologize that you're not getting closure today. You likely would not have anyway because the cases, no matter what I would have done today, are still going to go to trial. So let's get that part taken care of, and then I will conclude the motion to revoke matter at the conclusion of the trials in the other cases. All right. All right. I do want to thank everybody for being here. I know this is extremely difficult, and sorry for what everyone's going through and for your losses and all of that. Mr. Coleman, did you have something else?
Move to withdraw the exhibits, Your Honor, so that they can be used at trial.
Yes, sir. I will allow you to withdraw all of those exhibits. And again, we'll get a trial set as quickly as we possibly can. I'll look at some weeks, maybe even when we don't already have trials, so that it could be specially set if necessary. I know there'll be several witnesses. So I'll let you guys know as soon as we have that set.
I don't have any data stating that he stayed on the brakes all the way through the time of impact. I was not at the scene, so I'm bound by only what the data tells me.
But if you extrapolate and you account for if he stayed on his brakes, what would the speed of impact, what would the speed have been at the time of impact? That's given he stayed on the brakes. And again, that's tantamount to being speculation on your part, really.
Yes, and I'll be glad to tell you how I got to
Please,
it.
because I just want to get out in front of this. I'm sure Mr.
Okay, the speed at the time of impact was about 40 miles per hour, provided he stayed in the brakes.
And if there's anything else you want to add to that?
Yes, sir. The interesting part about that is if you look at the accelerator pedal position, you see that it goes from 99 to 0 for 1 full second, and then it goes back up to 27, then back up to 42. However, the brake lights are still on. So that would mean a couple of things to me.
Yes.
As far as being able to read these reports and analyze them. He either drives with both of his feet, one on the brake and one on the accelerator.
Or is that a form of, I'm sorry to interrupt, but is that one form of how people do burnouts? Or am I completely off base?
It's done that way.
Okay.
I don't think that was the case.
I'm sorry to interrupt.
No problem. But that minor acceleration is going to affect his deceleration caused by the braking effort that he was applying or trying to do. So that's the reason that I can't be exactly sure what the speed, and the reason I referred to it as The speed at the time of impact was about 40 miles an hour. He had, if you look at the reduction in his speed, he had lost 9 to 10 miles per hour per half second. So from 51, that would be about 40 miles per hour.
And let's just say, based not even on your training experience, but in your just everyday life experience, if a person is traveling 70 to 52 miles an hour in a residential neighborhood in a zone that's zoned for 30 miles an hour, is it fair to say it would make it difficult for someone to see that vehicle, that oncoming vehicle?
Seeing and judging the speed of that vehicle are two
I think that's a better way to put it.
different,
Right.
different
Judging the speed.
things. It's very difficult to, it's very, very difficult for me to judge the speed accurately of a vehicle that's approaching. I have had a lot of training in that area, and I can usually say, oh, he's running pretty fast. But as far as knowing the neighborhood of how fast he's running would be just guesswork.
That's a better way to put it, and I should have asked it in that form about judging the speed as opposed to being difficult to see. Thank you, Mr. Witten. Again, thank you for being your past witness.
Yes, sir.
Thank you, Mr. Coleman. Mr. Kurtz?
Hey, Mr. Wright, how are you?
I'm fine. How are you, sir?
Good to see you. So let's talk about the pre-crash data table that you have there.
Yes, sir.
I want to be clear for the court that unlike the accelerator position data, the brake switch is about whether or not the brakes are being touched at all, correct?
Yes.
It does not tell us.
It does not quantify the braking effort.
So the accelerator is quantified, the brake lights are not quantified.
That would be correct. Yes,
Okay,
sir.
so we can't tell how hard somebody's mashing down on the brakes, right?
That's correct.
But we can tell at least at some point how hard somebody might be mashing down on the accelerator.
We can't. That's correct. The only way that we can tell how fast he is decelerating is to look at the speed reduction as in the speed.
And that's an extrapolation that you make.
Yes, it is an extrapolation.
Okay. Here, let's be clear. You use the number 72 miles an hour at 2 seconds before impact. Is that correct?
Yes, sir. That was the highest speed that was recorded.
Okay. Now, at a full 2 seconds in advance of the impact, though, his foot comes completely off the accelerator, correct?
That's correct.
And then in 1.5 seconds before, his foot is on the brake in some manner or form, but we can't tell how hard, correct?
Yes, that's correct.
And it remains on the brake 1 second out, half a second out, correct?
Correct.
Now, you mentioned somebody maybe drives with both feet. Is it also possible, or would you make room for the possibility that maybe somebody's pressing with their foot on the brake because they weren't anticipating anybody pulling out in front of them, and they're just touching the gas while they're pressing hard on the brake because of the way their foot is?
I would have to admit that my feet are not big enough to do that, but I know some people's are.
Sure.
And
I mean, the
that
pedals
would be
are
a
not-
possibility.
The
Yes.
pedals are not far away from each other, right?
They're not.
And oftentimes I mean, you know this, you've investigated thousands and thousands of crashes. Oftentimes when something sudden happens, your immediate reaction is not rational or logical, right?
Sometimes it's not.
And it may not be perfect either, right?
That execution of that action is many times not perfect.
All right. Now, so what we can extrapolate is that at the time of impact, the vehicle was doing this vehicle was doing 40 miles an hour. Is that right?
Yes, about
Extrapolation, correct?
that's correct.
I just want to make it clear that that was not a determination. He said if.
Actually, I asked him if it was an extrapolation.
Sorry.
I think the court is clear on that.
Yeah.
And he never, after applying the brakes, sometime after the 2 second mark, there's no evidence here that he ever took his foot off the brake, is there?
No, sir. The brake shows to be on for the remainder of the table here.
And the speed continues to decelerate, correct?
Increase, yes.
And at 2 seconds, the accelerator is fully off. Is that correct?
That is correct.
Okay, so a full 2 seconds before impact, the accelerator is fully off.
It's showing 0%.
Okay. Now, do you recall testifying in a case a while back that you and I dealt with over in the drug court involving a woman named Tanya Bowman? Do you remember that case?
Yes, sir, I do.
Okay. And remember that in that case, the key issue was whether one car was speeding or whether the other car failed to yield the right of way, right?
That's correct.
And you and I went round and round and round about it, did we not?
We did.
It felt like days, right?
It was a long time. It was.
And ultimately, your
Judge,
position,
I would object to the relevance of that other case in this particular case.
Judge, it goes directly to his opinion about this.
Overruled. Go ahead.
Ultimately, your opinion was that if someone fails to yield the right of way, that they are the cause of the accident, in that case, regardless of the speed of the other vehicle. You remember that being your testimony?
Yes.
And so if someone pulls out and does not yield the right of way when they're required to by law, it was your testimony then, in that case, that regardless of the speed of the other vehicle, the failing to yield the right of way is the cause of the accident, right?
That would be correct, but I've got to qualify that answer just a little bit. We're dealing with two different speed limits, I think.
Sure.
I like to say I did not work the wreck. There's a lot of difference in being a little bit over the speed limit and being a lot of the speed limit.
Sure. Well, just for a reminder, that car in that case was doing 73 miles an hour and a 55.
I will renew my objection about drilling down on the facts of that other case for the purposes of this case.
Judge, I allowed him to qualify his answer. He's testifying as an expert. I'm asked that he be heard as an expert in this space.
The facts, unless the facts are exactly the same, it sounds like there's some similarities, but with that qualification, I think I understand where Mr. Wright's got.
What began as a hearing over probation ended with far more questions than answers. The judge refused to rush a decision, setting aside assumptions and making it clear that fairness matters more than speed. Even with strong opinions on both sides, the courtroom was reminded that every piece of evidence has to stand on its own before someone's future is decided. For the families, the defendant, and everyone watching, the wait for real closure is far from over. The next trial will decide whether this was a tragic accident, reckless behavior, or something in between. Sometimes justice isn't about getting an answer today, it's about making sure the final answer is the right one. But what do you think after hearing everything in this case? Did the judge make the right call by waiting for a full trial, or should a decision have been made today?